Are we also, we're on YouTube? Sorry, Mr. Nunez. Good morning. This is Judge Alyssa Perez presiding over the 210th District Court Civil Docket for January 15th, 2025. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Nunez, would you please call our first case?
Yes, ma'am. Page 1, calling cause number 2024 DCV 5627, Ruben P. Hernandez versus Rodolfo Castillo. Announcements, please.
Ruben Hernandez, the plaintiff in the case.
Rodolfo Castillo for the defendant judge.
Right, and this was, I believe it was filed over the extended holiday. We have it set for hearing. Bear with me. We have it set for hearing on Mr. Hernandez's request for a temporary restraining order. Mr. Hernandez, you may proceed.
Thank you, Your Honor. Judge, I filed my petition as you stated back in December, and then I filed a TRO. In this case, Judge, we have a tortious interference with contract case. My client, who's here and present today on the original contract, who signed the contract, there was a wrongful death lawsuit that occurred back in October the 30th of 2024. My client we signed her up. I signed the contract here in El Paso County on November the 2nd, which is about 3 days after the incident. After that occurred, Judge, my client who went to see Mr. Castillo for an immigration case, spoke to Mr. Castillo, and Mr. Castillo then coercively had her sign a contract on the wrongful death claim. When she didn't go see him for the actual wrongful death claim, she went for the immigration case. She told him she had an attorney. He convinced her to sign the contract. He initially had charged her $25,000 for the immigration case, and then coercively told her, well, I'll do it for free if you sign over the wrongful death claim. She told him, well, I'll sign it, but don't do anything on the case right now. He says, I'll hold on to it. And we won't do anything until you let me know. Next thing you know, on December the 4th, she gets a letter from Mr. Castillo that he had filed a lawsuit, which I would tell the court that it was a lawsuit that was filled with many errors. As Mr. Castillo didn't even know the facts of the case because he didn't really know the case because he partially interfered and tried to take away the case from myself. And so we're asking Your Honor on this TRO that Mr. Castillo refrain from contacting Ms. Lopez in any manner. We've had some contact with Mr. Castillo's office back since November. We had sent him a cease and desist letter. There was another call made to my client after that letter. When I sent another email to Mr. Castillo's office, it's been my understanding that they have not contacted my client anymore after that. But we just want to have a TRO in place for that, Your Honor. He had also since us filing this TRO, he's non-suited his case that he had initially filed on her behalf. So we would just ask in the TRO that he refrain from any legal matters and representing alleging to represent my client in any matters with the wrongful death claim, or make any statements, representations in the future. I don't think that's going to be an issue, Judge, at this point. We haven't heard anything else since the last contact we had with Mr. Castillo's office, but we'd like to have this TRO in place for those reasons.
All right, and Ms. Hernandez, if you are there, I do need you to, I don't see that you're muted, but I do need you to have your camera on, please. Oh. Mr. Castillo, I'll hear from you.
Yes, Your Honor. I think counsel is misstating the facts as he understands them. Excuse me, Judge. On November the 9th, Judge, Thelma Lopez Hernandez came to my office. I spoke with her directly. I did not call her. I did not solicit her. My office is located in San Antonio, Texas. The alleged breach of the contract or interference is here in San Antonio. We are responding and we're appearing subject to a motion to transfer venue that's now pending before the court. Additionally, Judge, if we could go back to the facts as stated by counsel, we signed her up on November the 9th, Judge. November the 11th, we initiated a claim with the carrier. We were not aware and we were not made aware that Mr. Hernandez represented her or anybody represented her. I asked her specifically, have you talked to any attorneys? Yes, I have. I've talked to several attorneys. Do you have a signed contract with anybody? I do not, is what was represented to me on that day. We then signed the contract. Exhibit A's to the motion to transfer has Thelma's signature and I'll copy of her driver license confirming that she did sign a contract with me. On November the 11th, we filed a lawsuit. We received the report on November the 14th. There was some correspondence between us and the carrier all through November and to beginning of December. Once we got a correspondence from the carrier that advised us that there's another party, not Thelma, another party that's involved. We filed a lawsuit so that we can make a determination of heirship. That was a preliminary lawsuit, so it wasn't fully filled with data. So all that said, Judge, we had Mr. Hernandez and I had several correspondence via email. When we found out about this additional case, we contacted Ms. Hernandez, explained to her via text, here's a copy of the carrier letter, here's a copy of the lawsuit we filed, we have to do some additional things. And that happened around December the 16th. But on December the 12th, Judge, prior to Mr. Hernandez filing his lawsuit on December the 19th, on December the 12th, we filed a petition here in Bexar County to determine what the matter was, if there was going to be a tortious interference, if there was potentially a barratry issue that needed to be addressed. Mr. Hernandez does not have an office here in San Antonio, does not have a staff here in San Antonio. So that became an issue for us. So we filed our petition on December the 12th. Subsequent and in response to our petition being filed, and in response to that, so as to avoid to give testimony or information, Mr. Hernandez is attempting to circumvent the civil litigation process by filing a lawsuit in El Paso. The defendant resides in Bexar County. The subject matter that gives rise to this issue occurred in San Antonio, the alleged breach, the alleged interference. So venue is proper in San Antonio. One, because we were not aware that there was a contract in existence. Two, Ms. Hernandez came to my office, solicited me, made an appointment. We reviewed all the information. We signed documents, and all that occurred in San Antonio. So venue is proper in San Antonio. A TRO is ancillary, as the court knows, to the lawsuit. And if the lawsuit venue is disputed and it's improper for Mr. Hernandez to bring the lawsuit in El Paso in a manner that's deceptive, and he understands that this is just blatant forum shopping. The facts occurred here. The defendant resides here. Civil practice and remedy codes dictates that the case be processed here in San Antonio. In addition to that, Judge, I have read the TRO that council has submitted. And there are no irreparable damages or imminent harm that would occur if the court bypasses the TRO today. We're set for next week on this matter to try to get depositions from both Mr. Hernandez and Mr. Ruben Hernandez counsel to determine what exactly happened in the chronology and see if there's material issues. And now Mr. Hernandez is saying that these issues arise on the same facts. However, there are separate causes of action that are here. For example, we're interested in bringing potentially a barratry case and in addition, an interference with our contract, because the way that we understand is that he had her initially and then she came to us. Hypothetically, let's just say I didn't know about it, or if I did know. The professional rules of ethics, rule 1.15D comment 4 specifically says that a client can hire a new attorney at any time, can fire an old attorney at any time. So those issues with regard to why he's bringing the lawsuit, and in order for him to get this TRO, he has to have a probability of winning the litigation. And because it's against public policy to tell a client, do not consult with another attorney, do not talk to another attorney, do not seek redress with another attorney. It's against public policy for counsel to ask for that. In addition to that, Judge, I want to make sure that the court is aware that that venue is in San Antonio. With regard to the TRO, it's ancillary to the lawsuit. The lawsuit is proper here in San Antonio. With regard to counsel's motion to abate, Judge, because there's a second motion that's in there. That motion is null in that he cites two specific cases. One case does not have anything to do with abatement. The second does have to do with abatement. And the second stands for the principle that the first petition, the first to file, dominates and has jurisdiction over the subject matter. So even his own cases that he cites in his motion to abate kill his argument to have this case abated. All that said, Judge, we want the court to understand that if this case proceeds here, the venue is improper. Ancillary remedy is TRO, because everything that happened with regard to the alleged breach happened in San Antonio, Texas, and Bexar County, Judge.
May I respond, Your
Okay,
Honor?
well, let me just, I'm trying, because I'm operating off a different type of device today. I have to kind of toggle back and forth. I want to be clear. I do see, I had reviewed the Odyssey entries as of yesterday. This morning, I do see that yesterday a motion to abate was filed by you, Mr. Castillo, if I'm not mistaken.
It was me, Your Honor. The motion to abate was for me. It was me.
Oh, plaintiffs, perdón. Let me pull this one back up.
Mr. Castillo filed a motion to transfer venue this morning.
Yeah, that is what I am not seeing.
Yeah,
And so when
it
you were
was-
referencing that, it's not showing up quite yet in Odyssey, so I have not seen that. Certainly, I'm sorry, it was a motion to transfer venue, is that correct?
Yes, Your Honor.
That was filed, Judge, but I don't think it's been accepted by the court yet.
Yeah, it hasn't been accepted
Filed
by
late
the
this
clerk,
morning.
and certainly it is not set today. Neither, frankly, not that it would have to be set, the motion to abate. Frankly, Mr. Hernandez is here. And yes, I'll hear from you, Mr. Hernandez, but ultimately I'm going to want to hear from her. In terms
Absolutely,
of
Judge.
venue, Mr. Castillo, you know, we're not, in my opinion, we're not there yet. But I'm still getting a handle on some of the factual representation. So Mr. Hernandez, let's go.
Yes, Judge, and just to kind of respond before I call Ms. Hernandez or Lopez Hernandez. Judge, the venues here is proper, and even in his response, when the court eventually will get it on his motion to transfer, there's a case there that cited Colleen versus Lighthouse Electric Contractors, 248 Southwest 3rd 343. In that case, Judge, it says that if the original contract was signed in a particular county, then that gives rise to, or that constitutes a substantial part of the events giving rise to the tortious interference claim. It's specific on a tortious interference claim. I signed the contract here in El Paso County, so
On what date was that contract signed?
that was signed November the 2nd, 2024.
Okay.
So that his motion to transfer venue is not an issue, Judge. This is a proper venue. And he even states the case he cites his motion to transfer venue states that same case. And so venue here is proper. In reference to the petition that he filed, it was not even a petition, it was a notice to try and do an investigatory deposition to see if he had a claim to file in San Antonio. He did not file a claim, even though I had sent him everything in advance of what was going on. He filed a notice. There's no petition, there's nothing filed. I'm not served with the lawsuit. There's nothing pending as far as a claim in San Antonio. The only lawsuit and claim that's filed is here in El Paso County, which proper venue because I signed the contract here in El Paso County. But yes, Judge, we will call Ms. Lopez Hernandez, and at all times you'll see, Judge, that she told him not to move on this case. He coercively induced her
Mr. Hernandez, your feed is breaking up.
a contract in San.
Mr. Hernandez, your feed is breaking up, so I'm missing
Yes.
some audio here.
Maybe if I take out video, Judge, maybe the audio will sound better.
Okay,
How about now, Your Honor? Is that better?
as far as I can tell. All right, let's go ahead and call her,
Okay.
ma'am. Let me go ahead and swear you in, Miss Lopez Hernandez.
No, good morning, George, and I'm so sorry. I don't know speaking really good English, so
Do we have an interpreter, Mr. Hernandez?
I don't, I do not.
Yeah, I have very bad audio on both of Mr. Hernandez and Miss Lopez Hernandez. We also need an interpreter.
Can you put us on hold and we contact the Council of Judges, Your Honor?
So I'll come back to you all. Well, yes, we'll put you on hold. We'll get to some of these other cases, but there's more than just the language issue. It's also this connection. It's not stable. So we'll pause on that hearing, on the TRO hearing. Frankly, if we're going to have these issues, I'm going to require that this be done in person at least. Is Miss Lopez Hernandez in El Paso?
Judge, but she's not in El Paso, Judge, but we can have her here. We can bring her in.
We're just going to need better connections. Mr. Castillo, I would not require that you appear in person. We can do somewhat of a hybrid proceeding, but
We can, Judge, and even if the court, if I gotta come down there physically, Judge, we'll take care of it. We'll hammer it out one way or another, Judge. I'm open to travel to El Paso.
I just
if
feel
need
like
to.
we've got some hiccups here. Let's see if we can resolve them now. So we're going to take a quick break. Mr. Castillo, Mr. Hernandez, and Ms. Lopez Hernandez, you can go ahead and pause your video and audio and see if we can get some of those things fixed. And then we'll come back to this case.
Yes,
Okay.
ma'am.
Monday.
If I may interrupt for a second and just to let the parties know, the Council of Judges does not provide interpretation for civil cases.
Okay.
That was my recollection. So unless, Mr. Hernandez, you have a good connect with an outside interpreter, we may need to reschedule. We can
Okay.
reschedule quickly, but we'll need to
Okay.
reschedule.
Okay, let me see what I can do, Judge, in the meanwhile.
Thank you. I'm going to go ahead and mute you, Ms. Lopez Hernandez, and Mr. Castillo, if you'll go ahead and just mute and black out. We'll see if we can come back. All right, Mr. Nunez, who would be the next case?
Page 1, Judge.
Mhm.
Calling cause number 2024 DCV 3015 Molina Outdoor Inc. versus Texas New Tactical Corporation. Announcements, please.
Good morning, Your Honor. This is Erica Stickney on behalf of the plaintiff, Molina Outdoor Inc.
Okay, anyone here on behalf of Texas New Tactical? We are set for default hearing bear with me. I don't usually just operate off of one screen, so I'm toggling. It takes time, but I reviewed it yesterday. And so you may proceed, Miss Stickney.
Thank you, Your Honor. I'm Erica Stickney. I'm here on behalf of Marolina Outdoor Inc. We filed our petition back in June 26, 2024 for breach of contract, sworn account, open account. It was for purchase of clothing items and other stuff, like promotional stuff. We served the defendants on July 9th, 2024. We served the registered agent by personal service. No answer was filed, and we filed our motion for default judgment on November 19th, 2024. We're seeking a judgment in the amount of $11,354.48, as well as prejudgment interest in the amount of 5%, and from the default going forward, and post-judgment interest in the amount of 5% plus court costs and attorney fees in the amount of $1,200. And I ask that the court take judicial notice of the file.
Court will take judicial notice of the file. Sorry that my system is so slow. Notice of hearing, let me see, that was November 27th. Did we send notice of the hearing to Texas New Tactical?
Yes, Your Honor.
Okay, how was that sent?
It was sent, let me pull it up. It was sent by certified and first class mail
Okay.
on November 27th. And yeah, it was sent to the registered agent who had also accepted service.
Okay, so with that representation, the court is going to grant your motion for default. I have reviewed the motion. All exhibits that are attached to that motion are admitted for purposes of this hearing. And if you will, you may have already, but it's very helpful if you just go ahead and resend any proposed default order, and the court
Okay.
will sign off on it for filing.
All right, thank you, Your Honor. Is there a specific email address I should send it to, or is it on your?
So, that seems like such a simple question, but as I was mentioning all the migration, I myself don't even know exactly. Ms. Hernandez, do we already have it?
Yes, Judge, I was going to interrupt and let Ms. Stickney know that I do have it. I just sent it to your
Okay.
email.
Perfect.
All right.
Yeah,
Thank you.
I
Thank you, Your
still have
Honor.
it.
Thank you, Ms. Hernandez.
Your excuse, thank you.
May I be excused?
Yes, ma'am. All right. Next.
Judge, on the same page, page 1, calling cause number 2023 DCV 1890, Cristina Sanchez Jaques versus Texas NVH LLC et al. Announcements, please.
Deborah Fisher on behalf of the plaintiff.
David Chavez on behalf of the defendants, Texas NVH LLC, and Fernando Nava, ready to proceed, Your Honor. Thank
I
you.
had a note. Good morning. I had a notation. This case had settled and this was kind of a 6-month down the road. Can you give me an update, please?
Yes, Your Honor. In fact, everything has been resolved and we filed a motion to dismiss this morning and have submitted a proposed order to the court and a copy to opposing counsel. So everything should be good to go, and thank you for everything.
Thank you for appearing.
Thank you, Your
Thank you
Honor.
so much. I'll check the emails.
Yes,
All
ma'am.
right, have
Thank
a
you.
good day.
You too. Bye-bye. Who's next?
Same page, Judge, but on my page, calling cause number 2024 DCV 1582, JPMorgan Chase Bank NA versus Robert E. Azar II. Announcements, please.
Renee Boteo for JPMorgan Chase.
Okay, anyone here on behalf of Robert Azar? Bear with me. Ms. Boteo, I am so sorry. It's like everything that could happen with a computer today is happening. Very slow and then having to toggle. This one I'm not remembering. Was it previously set, and my Odyssey is still loading, so I'll just ask. Was this previously set for default?
Yes, Your Honor. It was set for default, and I don't think we could confirm that notice was sent.
Okay.
Then we sent notice for the December 4th hearing, and I think you had an emergency, so we didn't appear. And now I'm looking to see if we sent notice after we received this one, but I'm not seeing.
Let me ask my staff, has anyone had any contact from Mr. Azar? Have we
I've
received?
No, ma'am.
Yeah, okay, okay. I'll let you continue to check, Ms. Bote, and let me know.
I don't see that we sent it for after we received the notice from the hearing.
Okay, can I ask, with the previous notice that you sent, I believe you said for the December hearing, did that come back?
I don't see any return mail, and we didn't receive any information back from that notice.
Okay. Yeah, I hate to reset this again. Are you prepared to go forward on your default?
Yes, Your Honor.
You may proceed.
Your Honor, this is a credit card debt claim case between JPMorgan Chase and Robert Azar. The plaintiff is seeking recovery based on a claim for account stated and requests that the court take judicial notice of the records in the court's file. The plaintiff's pleadings indicate the defendant opened this account on July 30th of 2016. The last payment occurred on April 12th of 2023. Charge-off occurred after default on November 30th of 2023, and we filed our original petition on April 12th of 2024. Service occurred by substitute service and posted to the home address on May 21st, 2024, and we filed our motion for default judgment on September 23rd of 2024. Your Honor, therefore, we're asking the court to grant a default judgment in the amount of $30,944.52. We're not requesting post-judgment interest, court costs, or attorney's fees. Thank you.
Okay, the court will take judicial notice of all documents in the court's file to include all attachments to your motion that was filed. Your request is granted. Again, if we already have a proposed order, great. If not, please just go ahead and send your default order to the court so we can sign off on it and file it.
Okay, thank you, Your Honor. And may I be excused?
You may. Have a good day.
Thank you too.
And Mr. Nanez, I say no. I'm not even sure what these AI notes are. Let's leave them for now because I see some names, Bianca and Daniela added, read AI notes. So
Stop
sorry.
AI. You can, sorry, Judge, they can stop it. I think it's an app that goes to my Zoom automatically, but I think, let me feed it. If I put, I think, stop.
I am not tech savvy enough to know what, and with all the
Where am I,
computer
Judge?
changes this morning, I don't know what's going on. Everything is super slow. All right. So let's go to the next one, Mr. Nanez.
Yes, ma'am. Page 2, top of the page. Calling cause number 2023 DCV 3788. Dwayne Johnson et al. Versus Armando Romo et al. Announcements, please.
Michael Fetchner for the plaintiffs.
And Alexandra Olenzik for defendants.
All right, so I have this down. Good morning. I have this down for a final civil pretrial. I did see we are set for trial, but there's a motion for continuance. But I also already received a new scheduling order anticipating that we are not going to trial on February 14th. Is that right?
We filed a proposed amended docket control order based on to go with our motion for continuance.
Okay. I mean, I don't want to assume it's agreed, but
it is not.
Oh, okay.
So
okay.
That's why we had to file an opposed motion for continuance.
Okay.
So we're happy to take that up with the court now. The coordinator also set it for your hearing docket next Wednesday. But if the court's ready to hear the motion for continuance now, I think counsel for defendants also ready to have it heard today.
Let's hear it.
So this is a case that stems from a 2023 crash. It was filed late in 2023 after substitute service. Defendant answered and discovery started in early 2024. Discovery has been ongoing. Written discovery is, I want to say, done. We had a problem scheduling the defendant's deposition. It was requested in the summer of last year. After multiple attempts to try to schedule that, we did get it scheduled in October of this last year, and then it needed to be canceled because communications between defendant and defendant's counsel had ceased. Plaintiff agreed to cancel the deposition and try to reschedule it. The earliest that they could be rescheduled was January 3rd, just a week and a half or 2 weeks ago. And from that deposition, there's a couple things that have come out of it. Number one, there's a new party that plaintiffs would like to add, as we are still within the statute of limitations. It's the company that retained the defendant driver to haul the load. The defendant driver testified at his deposition that that company did no safety check, no safety screening, and the driver had no safety rating at that time, as he was a new company. Per the contract between ATS and the defendant, they were supposed to do more than just sign off on a driver with no safety rating. The second thing is, we would like for our accident reconstructionist to be able to review the defendant's deposition and provide and disclose his opinions with the benefit of reviewing the defendant's deposition. The third thing is that we have requested and not been provided dates for the defendant's experts' depositions. And those requests have been ongoing for, I think it's 2 months, maybe not quite 2 months, but for quite a while. And no dates have been provided for their depositions. Finally, I have and other counsel of record on this case for plaintiffs have another trial setting that is conflicting with this trial setting. The other case is a preferential setting on its third trial setting in Dallas County. And those are our bases for moving for continuance and asking the court to enter in the amended docket control order. The short of it is, we need to finish expert discovery. We need to add this new party. And we believe we can have this case ready to go in the next 5 or 6 months.
Okay, thank you. Ms. Olensik?
Olensik, yes, Your Honor. Perfect, thank you. Yeah, Your Honor, frankly, this matter has been set for trial for, close to a year. It's set for trial next month. Plaintiff's counsel says, well, we were just able to depose the defendant. Well, and that's true. It came out during his deposition that he changed addresses and phone numbers and whatever. But we're in contact with him now, thank goodness. But as for ATS being a new party that they just discovered, Your Honor, we produced all the documentation about ATS in June with our responses to plaintiff's request for production, including.
Hold on, it was whatever information that came out in the deposition, was that apparent in the documents?
That
no, Your Honor.
Okay.
They knew about ATS 6 months ago, Your Honor, and that ATS had hired my client to haul this load. They even apparently knew, I'm not sure whether it was the manufacturer or whether it was the recipient of the load. But after the fact of this collision, Your Honor, there was an awful lot of correspondence going back and forth because of the purchaser's concern about the quality of that load after this collision. But anyway, so they've known about ATS for at least 6 months, Your Honor, and could have looked into ATS and ATS's policies and everything else, and they didn't do that. And as for expert depositions, Your Honor, we've been giving them dates. They've been refusing us dates, etc. So that's a mutual back and forth on with respect to experts, that we had given dates, they didn't give dates, back and forth. Oh, also, Your Honor, with respect to their recon expert was served late, Your Honor. Plaintiff's designation deadline was back on November 26th. And that was an extension, Your Honor. That we'd given them 2 extensions of their expert deadline. And they still didn't serve their expert report from their recon. They didn't announce their recon to us until the 31st of December. So we promptly filed a motion to strike their recon expert. So, their assertion that they want their recon expert to review the deposition transcript of our defendant is kind of meaningless because he's a late expert, Your Honor. It served 6 weeks before the trial date. Anyway, Your Honor, those were basically our issues with their motion to continue. We've been expecting to go to trial next month, and we're ready to go to trial next month. And, granted, I'll admit there's not much that I can do if plaintiff's counsel has conflicts. And that's up to Your Honor to decide upon those. But as far as we're concerned, Your Honor, we're ready to move forward.
Anything else, Mr. Fechner?
Yes, Your Honor. So first, there have been no defendant's expert dates provided for their deposition. I have no emails from defense counsel where those dates are provided. I don't recall any phone conversations where those dates have been provided. Secondly, the expert deadline was moved back because defendant's deposition had to be canceled when it was originally scheduled. Or excuse me, it had to be moved back because we could not schedule defendant's deposition until October after we'd been requesting it for months. Then we asked for it to be moved again after that deposition got canceled. To Melissa Lynchick's point, it was served, our accident reconstructionist disclosure, we did serve it after the agreed deadline to do so. As laid out in our motion, the report was ready, it was sent to the paralegal, and I'm not here to make excuses or say, we did not make a mistake, but for whatever reason, the file was not actually served. It was prepared. It's not a surprise to defendants that we have an accident reconstructionist. In fact, they had already designated an accident reconstructionist because they knew we had one, because they both went to inspect the vehicles together earlier in 2024. So it's been no surprise that both parties have accident reconstructionists. We've asked for extensions pending the defendant's deposition to disclose our accident reconstructionist. What brought along the delay was the inability to get defendant's deposition set and scheduled. That took over 6 months from the time we requested until we were finally able to have that deposition taken. So I'm not here to say that we did not make a clerical mistake and that we did not serve a reconstruction opinion by the formally agreed to date. We did. What I'm asking for is that this case be moved down the road so that we can do things the right way, so the reconstructionist has the opportunity to review the defendant's deposition, so that I can depose their experts, which I am entitled to do, and so that we can add in all necessary parties.
So I'm clear, we were scheduled today for a final civil pretrial. Let me just double check, possibly the motion for continuance. No, the motion for continuance set next week, but I am in agreement and the parties were in agreement to hear it today. I did not have anything. I see the motion to strike being filed on the 8th of January. I was not inclined to hear that. In addition, I thought the continuance obviously was more dispositive of a lot of things. The motion for continuance is granted. I understand the objection of defendants. If there is an agreement about a reset to August, I know that date has been put out there. Then we'll go with that date as best as the court can accommodate you. It won't be set before August. So what I will need from the parties is an agreed scheduling order. If the proposed one wasn't agreed, if you will recirculate it and work on that to make sure that we have agreements. I don't anticipate, let me look at the settings. Myrna will cancel out the docket call in the jury trial, but we need to have some time of type of entry of that scheduling order set certainly within 30 days. So normally it's a 2-week turnaround, but if there's some details that you all might need a little bit of time to make sure that we have the best scheduling order we can have, that we won't have to tweak in the future, great. And then with that said, Myrna, we will make this a special setting. So I know we're working on the calendar a little bit to make sure we have our civil cases kind of carved out when they actually need to go to trial. So if we get there, you all will be set specially.
That'd be great. Thank you, Your Honor.
Thank you
Excellent.
for your time.
Thank you.
And we'll submit a agreed order to the court for its review.
Perfect. We're also canceling that hearing next week at 22nd. Okay.
Understood.
Thank you for your time.
Yes, ma'am.
Thank you so much. You all have a good day.
You too. Thank
Bye-bye.
Let's go to the next one, Mr. Garcia, I believe. Here, we got our parties here.
Yes, ma'am. Calling cause number 2023 TCV 1852 Rafael Garcia versus Amira Link LLC et al. Announcements, please.
Good morning, Your Honor. Oscar Lara on behalf of Rafael Garcia.
Your Honor, Aldo Lopez on behalf of Defendant Swift.
Is Mr. Herrera there? Oh, my system is so slow. Anytime I click out of Odyssey, I can't get back in.
I saw him on there, Judge.
Yeah, I saw him here too, but he's not answering. Mr. Herrera, are you there? And my only notation is the status conference is status on discovery. And let me.
Yes, Judge.
Give me a second. Odyssey popped up. I thought I had made
And Judge, I think on the discovery, I think that was between me and Mr. Lara. And I can tell the court we had met and I promised to get Mr. Lara some supplementation. And unfortunately, I lost track of it, so I owe that to him. And I will get it to him ASAP. We did reach an agreement on a lot of stuff. And that was my fault, Judge. I just lost track of it with trial and the holidays. And I do owe it to Mr. Lara. So I don't know what we want to do here, but I've worked with Mr. Lara before, and you know,
so I can rely on you all. I know it, but while you're talking and I'm hearing all this wonderful news, I'm just looking at and that's fine. I'm just looking at the calendar or the schedule for this case. We're set next week. I kind of feel like we don't need to be set next week.
So yeah, Judge, I think next week we have your final civil status conference.
The final civil is February 26th.
Oh, okay.
So we have a final status. I feel like I just want to cancel that one and jump to where I think we need to be, which is, but this is odd too. We have a final civil pretrial in February and then your jury trials in May.
Correct, Judge.
Yes, Judge.
Okay. So the only thing, I'm not going to ask any more questions, I'm going to do is rely on you all to let me know if all this wonderful kumbaya does not happen and there's a hiccup. I'm sure somebody will file something and we'll get you set for a hearing. Then I'm going to cancel the January 22nd final status conference, and I will see you all in February for our final civil pretrial, which will precede our jury trial.
Thank you, Judge.
All right.
Okay.
Somebody,
thank you, Judge.
Mr. Herrera, no. Thank you very much.
Thank you, Judge.
Take care, guys. Bye-bye.
Thank you.
All right. Who's next?
Judge, did you want to do the default before you do the Rosales versus Ramsey?
Yeah, that sounds good.
Okay. Page 3, Judge. Calling cause number 2023 DCV 3746 Cavalry SPV 1 LLC et al. Versus Belen Quesada. Announcements, please. Ms. Kelter or Mr. Kelter?
John Kettler, are you there? All right. I'll put him in the waiting room. All right, let's go back to then, we'll go to the Rosales case, please. Do we have everybody here? I feel like
I think we
there's
do,
not enough,
Judge.
there's not enough boxes. All right.
Labinati?
Benatti, are you ready?
Yeah, Judge, sorry, I'm trying to find the box.
So I'm just gonna ask before we start, did we resolve everything?
We conferred, and I think we have limited much of the argument we were able to confer this morning, Your Honor, and I can take you through. I see on your notes for the docket that I think all you have is the motion for summary judgment, partial summary judgment, which we agreed upon. But our notice of hearing actually has special exceptions, which we also largely reached some agreements on, and a motion for a medical examination. And we can announce, I guess, what we agreed to the court on the first two, and then get to the motion for the ME, if that pleases the
That's
court.
exactly where I was. When I reviewed this yesterday, I thought I had read and hoped that's what you were gonna say, Mr. Grossman. So let me call it.
Okay.
Cause number 2023 DCV 3124, Ida Rosales et al. Versus Javier Ramsey Hernandez et al. May I have announcements, please?
Good morning, Your Honor. Daniela Labinalti for the plaintiff.
Bud Grossman for defendants.
Good morning, council. We are scheduled this morning on a motions hearing regarding a medical examination. We also had a motion for partial summary judgment and a special exceptions hearing. May I have an update on each of those?
Yes, Your Honor. Defendants are the movements on all three. So, and I'll just have Ms. Labinati, she can correct me if I mess this up. But the motion for partial summary judgment, you'll find there's a response, and it largely unopposed. It's a motion for partial summary judgment only on the issues of gross negligence and exemplary damages. With that being unopposed, I had planned to send a proposed order to Ms. Labinati for approval to submit to the court, granting just that motion for partial summary judgment on those issues.
We're in agreement there, Ms. Labinati. I did see your response.
Yes, Your Honor.
Okay, so I'll look for the order.
Thank you, Your Honor. And then on the special exceptions, there's only, I think, 3 of them, and they are in the defendant's first amended answer, which I had in front of me. There it is. That was filed back on October 20th of 2023. The first special, these are paragraphs 2, 3, and 4 on pages 1 and 2. The first special exception in paragraph 2 is simply compliance with the Texas Civil Practice and Remedies Code, section 30.014, that requires the last 3 digits of the driver's licenses and social security numbers to be pled in the petition. The next one has to do with just Rule 47, which requires just a maximum amount being sought. That one's pretty simple. The third one is in paragraph 4, has 2 elements to it. One is just the allegation of, quote, other negligence. I think we've agreed to omit or delete that so that I'm not left to determine what other negligence may be. The other has to do with Texas Transportation Code section 545.060, which is essentially making an unsafe lane change in violation of that particular transportation code statute, which my argument on that's improper in a negligence per se allegation because it's insufficient to allege or infer negligence per se with regard to a statute that adds nothing to the ordinary care standard. And as I understand it, we reached an agreement that we can have the plaintiff replead by adding the last 3 digits, pleading a maximum amount, omitting other negligence, and then withdrawing the negligence per se allegation. And I can again submit an proposed order to Ms. Labinati for her approval.
Is that agreed, Mrs. Labinati?
Yes, Your Honor, and I do need an order though, but yes, it's agreed.
Right.
And so the last remaining motion, Your Honor, is our motion for independent medical examination. The parties mediated the case were too far apart. I need to go through some steps. There's nearly $500,000 in medical that's claimed on behalf of Ada Rosales. And when that deals with medical issues, our good plaintiff's treating doctor, Vala Morovic, is treating and has run up quite a substantial amount of medical. And so I have a client, O'Reilly's is my client, and we've requested to have an orthopedic examination, much like Dr. Vala Morovic would perform. These usually take less than an hour. They go through the same steps of asking for a history. And I've conferred with Miss Labinati. I think she's, Dr. Gupti's a board certified neurosurgeon there. I found him they're in El Paso, so it should be least inconvenient. I had in my proposed order, mistakenly, I'd put mental and physical examination because I had another case where I had a mental examination too, but this one doesn't require that. So I told Ms. Labinati that I'd remove mental, but it's an orthopedic examination, usually takes about an hour. Any forms that would need to be completed by Miss Ada Rosales, I'll again provide those to Miss Labinati to help her client fill them out. But it's not a mental examination where you have a lot of discourse over cognitive deficits and things of that nature. It's a physical examination. So it's board certified neurosurgeon. There's no question of his integrity or his credibility. I always face well, let's videotape the doctor doing the exam, which is kind of puts the doctor on trial. I oppose that. The case law disfavors that. I've cited the case law in connection with that in our reply that we filed in the case. And in that connection, that's probably the biggest issue that you have to bearing on it. And the case that is pretty much on point is in that connection is the In Re Society of Our Lady of the Most Holy Trinity, which is actually an Corpus Christi case out of the 13th District, but it cites the Texas Supreme Court in Coates, the Coates case, and in that you'll find that it states the Texas Supreme Court held that the federal court's construction of the analogous federal rule was helpful to the analysis of our Texas rule, which deals with IMEs. And under the federal law, third-party observations and recordings of examinations are disfavored, quote unquote. And it goes on to say that this is because the introduction of a human or mechanical presence, whether a lawyer, a stenographer, a tape recorder, or other instrumentality, changes the nature of the proceeding. You know, there are special circumstances where you need recordings, and I get that if you have a minor involved or if it's more of a, something dealing with issues of integrity of a doctor, but we don't have any of those things here. And what you end up having is a production and intervention and interruption of what should take less than an hour. There's medical records that are replete in this case that have her history. And so a lot of it's going to be consistent with that anyway. So the doctor's going to do, a history of what her complaints are and then go through straight leg testing, all those orthopedic exam things that her prior doctors have already undergone. The other issue I think has been, well, you can ask the client, her client, anything under the sun. I'm certain we can restrict some of in the court's order upon approval by Ms. Labinati that, and I have here under a protocol that questions will be asked concerning the plaintiff's present illness and health history, medical, surgical, and social. This will include questions concerning current and past medications, therapy, etc. The detailed examination will address plaintiff's conditions that are at issue in the lawsuit. And I think she's had a medical procedure already done. So, it's pretty apparent what her complaints are. I think we'll be able to, as a neurosurgeon, delve into, we're not going to ask her things unrelated to her complaints in this accident, but we'll have a opportunity for us to have an examination that objectively, I'll have to own it, whatever he comes up with, obviously, because I'll have to share that report with counsel. But we'll have an opportunity for him to essentially lay hands on the plaintiff, so I'm not faced at trial with, well, you've never met or examined the plaintiff in this case, which is what we run into. And this helps me. I would tell you, we're too far apart from our last mediation, but I think this would be illustrative in trying to at least confirm some of the complaints that we have. And that's all.
Ms. Labinati, what is your position?
Well, Judge, my position is the law. So thank God this is not in federal court where they have a very different approach when it comes to IME. Rule 204 is very specific in the state of Texas. I mean, state cases, and specifically says, and I'm sure you've seen my brief, that, that councils have to comply. And I definitely have to say that Mr. Grossman has done a better job than most of my other defense attorneys on IME cases, which, by the way, all their IMEs have been stricken because they didn't comply. But I think I think he's done a better job at working to complying with Rule 204.1 and also the case that he cited in Sia Lady of Most Holy Trinity, 6/2021, Southwest 3D. So my only issue, Your Honor, was that you have to specify the scope. You can't just say, well, I want to IME the plaintiff. That's not the law in the state of Texas. State cases, you have to specify the scope, and you have to specify the examination, and you have to show that the person is qualified, and then you have to show that it's a matter of controversy, and then you have to show that the information you're requesting cannot be obtainable through any other means. That's the case law in the state of Texas for, of course, non-federal cases. So I know that Mr. Grossman produced an order that, it's pretty specific. It's pretty close to Rule 204.1 requirement, but it did have the word mental. And so we had to object in there because that was not in compliance. So he did correct that. Obviously, my argument was, especially if we're doing mental, that we're going to, I think that See Lady of the Most Holy Trinity specifically says, if there are children, if there is cognitive testing, videotape is allowed. I have other courts who have allowed videotape, and specifically in TBI cases. But I understand that now has been taken away. So we are not going to have any of those examinations. And Mr. Grossman has agreed to provide the intake questionnaires. And I mean, as long as that's specified, Your Honor, in the order, and I get this information that was literally provided to me or was told was going to be done 5 minutes before the hearing, I would work with Mr. Grossman, and I would, I think we can reach an agreement on that issue. As long as, again, I get the order to remove the word mental. I do want a resume of Dr. Gupta. Maybe he did include it, or maybe I missed it, but that is a requirement also. So I'm not saying he didn't say, I don't think I saw it, but if you can resend it to me again, that would be great. I just want to make sure there's no issues with regard to his qualifications, and I just want to make sure I have his resume. And then he did say it was only 1 hour, so that's fine. And then he told me right before the hearing that he'll provide an interpreter. So as long as also that's in the order, that they will provide an interpreter. I do need to know who the interpreter is in case I need to object to the interpreter. Believe it or not, as the court knows, we've had bad interpreters here in El Paso, and some that my experience as a trial attorney were actually kicked out in the front of the jury because they were not interpreting. So I'm sure the court knows the histories. But anyway, so as long as I know the name, so it gives me opportunity to object if I need to, then I am limited to the hours and limited to the scope, and I get the resume and the questionnaire, I think we can work it out.
Mr. Grossman, do you think that you all could finalize those details, and so the court has a better idea if you all do have an agreement in terms of proposed order within 2 weeks? Do you think?
Absolutely, and I would hope to do it within that time frame. I think in the order, just to be clear, the CV was attached to the motion of Dr. Gupta, but I will send another one. I have no problem. I get hundreds of emails a day, and when they're fresher, they're easier to find. But I will. Everything that Ms. Labinati requested, I think that's what we discussed this morning, and I did catch her after a deposition about 20 minutes ago. So But yes, we'll do that and submit that to the court. And I guess we would send that to one of the emails.
Yes, send it to Ms. Hernandez. What I am going to do is leave the hearing pending. I'm going to reset or continue it until the let me look at the right calendar, the 29th of January at 10:30 a.m. Frankly, if I have that order ahead of time and you all have agreed to it, just submit it to the court and that hearing is gone. But that'll be our marker to follow up with you all regarding this order. And frankly, the other orders. So I would assume the other orders are coming sooner on the summary judgment.
Yeah. I'll try to get all three to Ms. Labinati so she can approve them and get them all to you at the same time if I can.
Okay. Know that if there is some disagreement, we will continue the hearing at that date.
Understood and very much appreciated, Your Honor. Thank you for
Appreciate your
taking this
time and your
remotely.
efforts. Y'all take care.
Thank
Thank
you.
you, Judge. And I'll be in trial next week. So if I can get any orders by Friday, and if you can text me, because I'm probably not going to be looking at all my emails this week. I need to start getting on trial prep zone. Yeah, so because I'm not going to be available.
I understand. I'll make every effort to get them as soon as I can so you can have them.
Thank you.
Thank you, counsel. If you don't have anything else with me, you all are excused.
Thank you.
Bye, everyone.
Take care. We got Mr. Kettler back.
Yes, ma'am.
Okay, let's call that one. Calling cause number 2023 DCB 3746 Cavalry SPV versus Belen Quesada. May I have announcements?
Good morning, Your Honor. John Kettler for Plaintiff Cavalry.
Okay, and we are set for default hearing. Do anyone here on behalf of Ms. Quesada? No? Okay, you may proceed, Mr. Kettler.
Yes, Your Honor. This lawsuit was filed on or about 11/6 of 2023. This is with regards to a debt claim. More specifically, this account originated as a Best Buy Citibank account. However, after a period of non-payment, it was subsequently charged off, assigned, and then sold to Cavalry, who's brought the lawsuit. The court should have documentation as part of the plaintiff's motion for default judgment. We respectfully request you take judicial notice of those documents. In the plaintiff's motion for default, it should in substance contain an affidavit of the account, documentation attesting to the transfer of the ownership of the account, and then finally relevant account level statements that show the activity on the account within the statute of limitations, as well as the balance that we're seeking. Also, notice of today's hearing was provided to the defendant according to our records by certified mail return receipt requested. Defendant should have been notified also that this was a hearing to be conducted via Zoom. Your Honor, if everything is in order to grant a default, we're respectfully requesting that today for the amount of $5,449.71 plus costs of court, and then post-judgment interest at the current rate of 7.75%.
Okay, thank you, Mr. Kettler. The court will take judicial notice of all documents in the court's file, as well as the attachments to the motion for default. The default is granted. If you have not previously sent, I would say if you haven't sent that proposed default order, say in the past week or so, please resend it. It makes it easier to find. We can sign off on it.
Understood, Judge, and direct email to the court clerk.
Yes, thank you.
All right, understood. Thank you, Judge. May I be excused?
You may have a good day.
You too.
All right, Mr. Hernandez, did we get our court interpreter?
Yes, Judge. I need to send her a text as soon as we were ready. So let me send her the text.
And on that 11:15, is that one taken care of? 3425 Pies? Or are we gonna?
Yes, ma'am.
It is? Okay, great.
It is, Judge.
Thank you. We'll go ahead and just take a quick, like 5-minute break.
Yes, ma'am.
Okay, thank you, Judge.
Hello, can you hear me?
Yes, ma'am.
Yes,
I can.
Okay,
Good morning, Ms. Hernandez. The judge took a 5-minute break real quick.
okay,
Good morning. I have the name of the witness as Telma Lopez Hernandez. I called your office, right?
Yes, that's correct. Terma Lopez Hernandez is fine, yes.
Okay.
En el paso.
Ujú.
En el paso.
All righty. Hi, Ms. Hernandez. Oh my goodness, there's all puros Hernandez aquí, Mr. Castillo. What are you gonna do?
I see that.
We're everywhere, Judge.
Oh, hijola. As bad as Garcia and Perez, huh?
Too late for me. I'm the oldest, so I can't change my last name.
My
Well, I
middle
didn't
name
get
is
married or
Perez.
anything, so I'm still just Perez. So
My
we're
middle name is Perez, Judge, so.
all right.
Well, Happy New Year to everybody.
Happy
Feliz
New Year.
año.
Let me get back to where I was. Let's see. All right, so before we get right back on the record, Mr. Nunez, you want to set up the interpreter function?
Yes, ma'am.
Ms. Lopez Hernandez, in a second, they're going to turn on a function on Zoom that says interpretation. You're to select Spanish. I will ask the attorneys, you all select English, please, otherwise I will not hear you. I can, yes, ma'am.
Sí, listo, ya lo puede poner.
Yamilet,
Sí.
sale ahí donde dice, abajo está una cosa donde dice more o más. Y son como tres botones, o sea, botoncitos dentro de un círculo. ¿Lo ves abajo, a mero abajo? Si le aplastas ahí, sale para interpretar y tienes que aplastar ese botón y luego aplastar español, Spanish.
Sí, sí la oigo. Sí.
Okay. Again, attorneys, just a reminder, we're going to go ahead and get back on the record. We are back on the record in cause number 2024 DCV 5627 Ruben P. Hernandez versus Rodolfo Castillo. This is, we are resuming the TRO hearing that we began this morning. I believe Mr. Hernandez was about to call Ms. Lopez Hernandez. She is now utilizing the assistance of a court certified interpreter, Ms. Patricia Hernandez. Ma'am, would you state your name for the record, please? And I mean the client, yes.
Sí, mi nombre completo es Telma Yamilet López Hernández.
Ms. Lopez Hernandez, you have been called as a witness for this hearing, so I do need to swear you in. Please raise your right hand. Do you swear or affirm that any testimony you provide today will be the truth and the whole truth?
Es correcto.
Thank you very much. You can put your hand down. Mr. Hernandez, you may proceed.
Thank you, Your Honor. Ms. Lopez, you understand why we're here today?
Sí, sí entiendo.
Ms. Lopez, did you hire me and sign a contract back on November 2nd of 2024 in reference to a wrongful death claim?
Así es correcto. Al abogado Rubén Hernández.
And you hired me on that day. Did you have other issues that you had talked to me about in reference to immigration?
Oh, perdón, es que se cortó y no No, no pude escuchar lo que dijo.
Okay. Well, let me strike that. Let me go back. The wrongful death claim was that in reference to your daughter's father?
No. Mm,
The contract that you signed, what was that? What was your understanding of the contract you signed with me?
No no le estoy entendiendo a qué persona me está hablando. ¿Estamos hablando del caso del señor Castillo o del señor Hernández?
Okay, right now we're talking about the contract with me and you. Correct?
Sí, pero no le estoy entendiendo de qué abogado es que no le entiendo la pregunta de quién me está preguntando primero, de si es de Mr. Castillo o Mr. Hernández.
I'm asking about Mr. Hernandez, my contract first.
Ok, sí.
Okay. The contract with me, with Mr. Hernandez, that was in reference to a wrongful death claim with Mr. Garcia, correct?
Así es.
And Mr. Garcia is your daughter Ninetzi's father, or he was, correct?
Sí, es correcto, Ninetzi.
And Mr. Garcia passed away in a vehicle accident on October 30th of 2024, correct?
Sí, es correcto.
And again, for the court to understand, you signed the contract with me, Mr. Hernandez, on November 2nd of 2024.
Sí, es correcto.
And so that the court can understand your relationship to me is my two sons are your youngest daughter's first cousins, correct? They're first cousins.
Sí, es correcto.
So Gabi and Esteban and Alex are first cousins, correct?
Sí, es correcto.
Now, you have other issues, legal issues that are pending right now, correct?
Sí, es correcto.
And those issues deal with immigration issues, correct?
Es correcto.
And you went to visit Mr. Castillo on November 9th of 2024, yes?
Sí, es correcto.
And what was your reason for going to see Mr. Castillo?
Yo lo fui a buscar para que me ayudara con mi estado para una representación migratoria.
And what was the price he initially quoted you to represent you in that matter?
Me dijo que era gratis. Él me dijo que no me iba a cobrar nada, que era todo absolutamente gratis.
Okay. Before he told you it was free, did he give you an amount of what he would charge on a case like that?
El señor Castillo no, su secretaria sí me dijo que me podía, el caso variaba, pero por lo general era de 3,000 a 5,500, un caso como el mío.
And when you talked to Mr. Castillo, did you have any intent to hire him on the wrongful death claim?
No, solamente tenía intenciones de agregarlo en mi caso personal, no el de mi hija.
And again, your personal case was the immigration case, correct?
Es correcto.
Now, once you started talking to Mr. Castillo, what happened that you signed a contract with him for the wrongful death claim?
Porque estaba confundida, no me siento que en ese entonces no estaba, me sorprendió porque él me dijo como que él me iba a ayudar, que él quería ayudarme, que él quería, él sabía todo lo que yo había pasado. Yo tengo una niña que está en tratamiento con cáncer, entonces él me dijo que él me quería ayudar, que él quería ayudarme, que me podía ayudar con mis 3 casos. Si yo firmaba con él, que él no me iba a cobrar absolutamente nada.
And did you tell him that you already had an attorney on the wrongful death claim?
Sí, yo le dije a él que mi otro abogado me, me iba a ayudar a pagarle a él su precio de migración, lo que él me iba a cobrar, que le dije que alguien me iba a ayudar y me dijo que quién, le dije que mi abogado me iba a ayudar a pagarle los honorarios a él.
So you told him that just so the court can understand, you told him that you had an attorney already on the wrongful death claim and that your attorney would help you pay Mr. Castillo's fees on the immigration fees, correct?
Es correcto.
So you're telling the court today that Mr. Castillo had 100% knowledge that you already had an attorney on the wrongful death claim, correct?
Es correcto.
And did you at any point tell him to do anything on your wrongful death claim?
No.
And the contract that you signed then, you're telling the court today that you had no understanding of what you were signing?
Ese contrato es el único contrato que estaba en inglés. Los otros 2 contratos de migración estaban en español. Solamente ese estaba en inglés.
Okay, so he didn't even provide you that contract in Spanish, correct?
Es verdad.
And for the court to understand, you still want me to proceed representing you on the wrongful death claim, correct?
Sí, el abogado Rubén Hernández.
And you've on December the 4th, you received a letter from Mr. Castillo, correct?
Es correcto.
And on that letter, he told you that he had filed a claim on your behalf in the wrongful death claim, correct?
Sí, es correcto, pero perdón, era vía mensaje, no era carta, era un mensaje de texto que él decía que ya está bien procesado, que ya tenían como un avance y ya habían metido una demanda.
Was that a surprise to you?
Sí, porque la última vez que yo hablé con el señor Castillo fue cuando fui a su oficina y habíamos quedado que yo iba a ir a hablar con otro abogado el día lunes, pero ya no me presenté porque sentí como, no me sentí a gusto que él no me estuviera cobrando dinero por sus honorarios. No quería, am, me sentía mal por eso, entonces ya no quise, ya no tuve ningún contacto con él hasta que recibí el mensaje y me sorprendí porque yo no sabía que era eso, entonces yo se lo mandé a Mr. Hernández y le dije que no entendía que era eso y ya me explicó él lo que era.
And it was your understanding then that on that next day is when I contacted Mr. Castillo's office in reference to why was he representing you when you never gave him any authority, correct? Is that your understanding?
Sí.
Now, when you were sitting in Mr. Castillo's office that day, did he approach you physically?
Sí, sí, él me dijo que él me iba a ayudar, que él me iba a ayudar, que no me iba a cobrar nada y que él iba a mover el cielo ah, para poderme ayudar y que yo me pudiera quedar aquí con mis hijas.
And did he guarantee he was going to fix your immigration case?
Sí, él me lo garantizó.
And when he approached you physically, did he grab your hand and make you feel uncomfortable?
Sí, me sentí incómoda, no por él, sino por mí, porque he pasado muchas cosas y cualquier persona que se me acerca siento algo como un rechazo.
Now, you're telling the court today that you're asking that Mr. Castillo not do anything in reference to your wrongful death claim, correct?
Sí, porque yo le mandé mi abogado Rubén Hernández, ya le había mandado a decir que no queríamos saber, no queríamos tener nada que ver con él, ninguna representación ni legal, ni de migración, ni de ningún tipo, y él no quiso retirarse.
And in fact, after we told Mr. Castillo not to do anything, their office contacted you one more time, correct?
Sí, es correcto.
And you're asking the court that Mr. Castillo's office or Mr. Castillo in any way that they not contact you, correct?
Es correcto.
Okay, we'll pass the witness, Your Honor.
Let me just get some clarification from Ms. Lopez Hernandez. You mentioned that Mr. Castillo was going to help you with 3 cases. What were the 3 cases that you were seeking his assistance?
Era el caso de inmigración, caso penal y el caso del accidente del papá de mi hija.
And Judge, and just to clarify, it's the criminal case that goes in hand with the immigration case.
I'm not understanding.
Es
Okay.
correcto, pero son. Sí,
Judge,
Let me
Judge,
hear
it's,
from her.
yeah, and I can ask her so she can clarify. Ms. Hernandez, you were a lawful permanent resident at one time, correct?
es correcto.
And there was an order of removal that was issued by an immigration judge back in, I believe, 2021. Is that correct?
Sí, es correcto.
You were given a sort of permission of supervision to stay here these last 3 years, correct?
Es correcto.
And the 3 cases that you were referring to that Mr. Castillo wanted to help you on or offered to help you on was the wrongful death claim, correct? That was one of them?
Sí, ese es uno.
The second one was the immigration case, correct?
Es correcto.
And the third one is the criminal case, the conviction you have and that was the reason for the deportation on the immigration case, correct?
Es correcto.
And Mr. Castillo guaranteed that he could overturn your conviction and keep you here as a resident, correct?
Sí, es correcto.
I'll pass the witness, Judge.
No, but see, here's where I am not clear, Ms. Lopez Hernandez. When you said that you asked Mr. Castillo to represent you on 3 cases, right? That's what you said.
Judge, I'm sorry, if we go back to the record, her testimony was Mr. Castillo asked her to represent her in 3 cases. She didn't ask Mr. Castillo to help her under 3 cases.
I don't want to hear it from you, Mr. Hernandez. I want to hear from Ms. Lopez Hernandez what her intention was when she said she signed up 3 cases. Ms. Lopez, you said that you tell me what 3 cases you were talking about that you handled with Mr. Castillo.
Bueno, nada más, él me dijo que él quería agarrar mis 3 casos, el de migración, el penal y el caso de mi hija. Él me dijo que él quería agarrar esos 3 casos, pero yo le dije que yo nada más lo quería para que me ayudara con mi caso de migración, pero me dijo que que pensara bien a lo que quería y que si quería, él me podía ayudar y que él me garantizaba que iba a mover el cielo para poder ayudarme y todo saliera bien a mi favor.
In that conversation, did you tell Mr. Castillo that you had already hired another attorney on the wrongful death case?
Sí, desde el principio, cuando yo llegué a su oficina, yo le dije que mi abogado iba a pagar sus servicios de migración.
All right, Mr. Castillo, go ahead.
May I proceed, Judge?
Mr. Castillo, I need you to select English because I can't hear you.
Can you hear me now, Judge? Can you hear me now, Judge?
I can't hear you. Walter, can you
Okay.
hear him?
I hear him okay, Judge.
I can hear him, Judge, and I can hear you as well.
I can't. Yeah, you need to select the English channel. Mr. Castillo?
How would I do that, Judge? On the YouTube or where? It looks like my mic's working on my Zoom. Give me 1 second, Judge. Let me see if I can get one of my texts in here.
I can hear him. I don't know, Judge.
So, yeah, I mute. I mean, if I unmute original audio, I probably could hear him, but that's not gonna work for the interpreter. So I could hear you, and I'm assuming you selected English, and
Yes, ma'am.
yeah. So he needs to select English. Let's give him a second.
Ya está bien.
Thank you, Mr. Hernandez.
Test. Can you hear me now, Judge? No.
Mic test, mic test. Can anyone hear me?
The judge can't hear. She said we have.
I cannot.
Test.
Mr.
Test,
Castillo, are
test.
you there?
He's trying to speak to you,
I'll
Judge.
unmute original audio, but I don't know, Ms. Hernandez, I don't think that's gonna work because. Sure.
He was trying to speak to you, Judge. He's got a tech in there with him trying to fix it.
Okay, I'll mute original audio again and see if this works.
Sí, sí la escucho. Sí.
If someone can convey to the judge, I'm gonna leave and then try
I
to come
can
back
hear
in.
you, Mr. Castillo. Now I can hear
Oh,
you.
okay.
So turn on your camera, and then I think we should be good to go. Okay. Okay.
Sí, sí la escucho.
Okay. All
Can I
right.
proceed, Judge?
Yes, you may.
Ms. Lopez, my name is Rudy Castillo. Do you remember coming to my office to meet me?
Sí, sí me acuerdo.
Do you remember that we talked about your immigration issues and also the wrongful death case?
Sí, sí, yo le platiqué todo mi caso.
Ma'am, we talked specifically about the fact that you have a conviction for alien smuggling, that you were a permanent resident and that you got arrested for that.
Sí, es correcto.
You informed me that you had a daughter who had cancer and a husband or your daughter's father just passed away. Is that true?
Sí, es correcto.
And when you came in, we reviewed those matters and we talked about how everything happened, the fact that you said that the officers forced you to take a plea, and that because they forced you to take the plea and because of the circumstances that they put you in, you pleaded guilty to that offense, correct?
Sí, es correcto.
And because of that, you lost your permanent residence. Is that true?
Sí, es correcto.
Okay. And then we talked about what needs to happen for us to try to reinstate your case. And at that time, you would agree with me that I said I would try to move heaven and earth for you because of your circumstance with regard to your daughter and your recent deceased husband.
No era mi esposo, era solamente el papá de mi hija.
But you would agree with me that what I just said is true, that I would try to move heaven and earth for you in those cases, correct?
Sí, eso dijo usted.
Okay. And did you think that that was a guarantee, that I guaranteed you that I could do that?
Sí me hizo sentir usted que sí lo estaba, me lo afirmó que sí usted podía hacer que yo me quedara aquí.
But in fact, ma'am, don't you already have a permission to stay here? You have a permit that allows you to stay here called supervised release.
Sí, pero tengo una orden de deportación también y usted me dijo que metiendo a migración el hecho de que el papá de mi hija había fallecido y ella no tenía con nadie más con quien quedarse, que usted podía hacer que nunca me deportaran.
So you felt that that was a guarantee, correct?
Sí, yo sentí que era una garantía.
Okay. And then when we talked about those cases, you also stated that you're I'm gonna call him your husband. I know he's your baby's father, but for the sake of the court, the father of your baby, we talked about that case as well, correct?
Sí, me dijo que cuando había fallecido, usted me preguntó lo que, qué había pasado con él y yo le dije lo que había pasado.
And then I asked you specifically, have you talked to an attorney? And your response was yes, I have. I've talked to several attorneys. Is that true?
Sí, le dije que yo le dije que tenía mi abogado y que mi abogado era el que le iba a pagar sus servicios, pero que también ya había hablado con varios. Pero con el que tenía, él iba a pagar los servicios de migración.
Okay. So based on everything that we've talked about right now, I'm going to ask you some other questions, man. Do you feel that, and anything that we said right now, that you were coerced or forced to sign a contract with me?
Yo me sentí segura de lo que me dijo, que me podía ayudar y eso me dio mucho aliento, pero después me sentí incómoda porque no tenía que pagar nada y sentía que no estaba bien.
Okay. In fact, we signed
I need
three
to stop right
separate.
there. Hold on, Mr. Castillo. I need to stop right there. So at the moment that you spoke with Mr. Castillo, Ms. Lopez, and did you sign 3 contracts to retain Mr. Castillo? Is that what you did?
Firmé con el señor Castillo para verlo, firmé uno, pero no sabía qué era. Y cuando fui a la oficina, nada más con la señora que hace los contratos, firmé 2 contratos en español, pero ella me dijo, le dije, solamente son los de migración, ¿verdad? Dijo, sí, dijo, no va a firmar nada hasta el lunes que venga. Si acaso quiere escuchar al abogado John, que es el abogado penal, y él ese abogado le va a explicar todo lo de su contrato si quiere para que firme con él el lunes. Pero ahorita esto nada más, y la señora me garantizó y ella me dijo, esto nada más es de migración y es del caso de usted, del caso de su hija, usted lo va a hablar con otro abogado, dijo, y va a firmar con él si quiere firmar el contrato el lunes, dijo, pero esto o el día de hoy nada más es de migración. Así me lo dijo ella, la señora que hace los contratos.
Go ahead, Mr. Castillo.
Ma'am, this is the contract that you signed. We've submitted it to the court. Is that your signature as far as you can tell? Right here up
Sí,
top?
es mi firma.
Okay. And did you sign 2 other contracts for immigration separately? You would agree with me that that's a true statement as well, correct?
Sí, con otra persona, pero ella me dijo que era la persona de los contratos que los iba a firmar y yo no estaba segura y me dijo, si quieres, dice, te puedo dar tiempo y no, porque no estaba segura de firmarlos.
But you did in fact sign that day, correct?
Sí.
All right. Ma'am, let's go back to the contract. Now, I don't have a copy of the contract signed by you with Mr. Hernandez with me, but how did you tell me immediately after your daughter's father passed away? When did you contact Mr. Hernandez? Or did he contact you?
No, yo me puse en contacto con él. De hecho, yo le pedí ayuda nada más para que me di como asesoría para poder sacar como sus pertenencias de la reca donde llevan la troca y yo le pedí ayuda que si yo, una pregunta si yo podía sacar las pertenencias de él y ya después él me explicó todo y me ayudó y hicimos el contrato.
Okay. So when did you do the contract? Like where did you do the contract? Did you go to his office?
Sí, en El Paso.
Okay. Did you sign with the blue pen or a red pen? What color pen was it that you signed?
No, en la computadora.
Ma'am, is it your and again, this is for clarity for me, is it your desire to have Mr. Hernandez represent you in all of these matters?
Solamente el caso de mi hija.
Okay. I just
I need to be clear. We're talking, when you're saying the case of your daughter, are you saying the wrongful death claim?
Exactamente.
All right, Mr. Castillo, go ahead.
Judge, we pass the witness, Judge.
Mr. Hernandez, do you have anything else?
Just quickly, Judge, Miss Lopez, the contracts that you signed with me were both in English and Spanish, correct?
No, solamente en inglés el contrato que es este. Este estaba en inglés. Y los otros dos en español.
Okay, and those were, you're
Aquí está
referring to Mr. Castillo's
donde no
contract,
iba a
correct?
pagar nada.
Miss Lopez.
Y estos están en español. Todos los.
Miss Lopez, please listen to the question that is being asked. Mr. Hernandez is asking about the contracts that you signed with him, not with Mr. Castillo.
The contract that you
No,
signed.
estos son, sí.
Yeah,
Sí,
the
estoy hablando.
contracts, let me repeat the question. The contracts that you signed with me, Mr. Hernandez, one was in English and one was in Spanish, correct?
Sí, con el abogado Hernández, sí.
With Mr. Castillo, you signed the 3 contracts, 2 of the immigration contracts, both of those were in Spanish, correct?
Es correcto.
And the one contract you signed for the wrongful death claim for your daughter Nenetsi, that was only in English, correct?
Sí, pero yo no sabía qué era, por eso lo firmé. Es esto, yo no pensaba que era un contrato porque no está ni siquiera profesional y por eso lo firmé, es el que está en inglés. Pero no sabía ni qué decía nada. Yo pensé que nada, porque como él lo estaba haciendo en pluma, pensé que era para que tomara mi caso él, pero no pensé que fuera un contrato.
Okay, no further questions, John.
Anything else, Mr. Castillo?
No, Judge, we really just wanted to hear from her, and we hadn't heard from her. I know counsel represented that we made an additional contact with her, but
No, I just want to make sure we don't have any other questions for Ms. Lopez.
oh, no, Judge.
Thank you, Ms. Lopez. Mr. Hernandez, do you have any other witnesses?
Your Honor, I would call Mr. Castillo.
Mr. Castillo, raise your right hand, please. I'm going to go ahead and excuse you. I mean, I didn't request it. Well, I don't know. Mr. Hernandez is the one that asked for you to be here.
Judge, we can excuse her.
Okay, thank you very much, ma'am.
Thank you, Mr. Hernandez.
Mr. Nunez, if we can turn off the interpreter function, please. You take care. All right, Mr. Castillo, raise your right hand, please. Do you swear or affirm that any testimony you provide will be the truth and the whole truth?
I do.
Thank you very much. Mr. Hernandez, you may proceed.
Now, Judge, before we proceed, I'd like to, or maybe the court, I know Mr. Castillo, I don't know if he does criminal law or not, but I don't know if he, at this point, he wants to take the Fifth Amendment because there could possibly be criminal charges for battery for what he's done and committed here. So I don't know if the court wants to admonish him on that, or if he understands that, and we can proceed.
Quite frankly, you know, certainly it's your right to call witnesses, Mr. Hernandez, I'm sorry, Mr. Castillo. I'm not sure where we're going with this, but if obviously you're an attorney, if you need the assistance of counsel for this questioning, then I'm going to pause. I'm going to pause the hearing for today and allow you some time to contemplate that, and we can resume testimony if Mr. Hernandez wants it. Quite frankly, at this point, the court is comfortable with much of the testimony and the documents that have been provided in the request for the TRO.
Judge, well, go ahead, Mr. Castillo.
So I know Mr. Hernandez wants, with regard to my testimony, Judge, right now, this is not my testimony, correct?
No.
Okay. With regard to my testimony, if counsel is going to question me like that, then I will request an attorney to be present on my behalf. For me, we're here basically on a preliminary order for TRO. That's what we're here for. We're not set on anything else. I think. Are
you making an objection to?
Yes, Judge. I'm going to object on the record and like to get a ruling with regard to Mr. Hernandez's line of questioning.
What is the scope of your request to question, Mr. Castillo, Mr. Hernandez?
Well, Judge, it goes directly to his solicitation, his coercion of Ms. Hernandez, Lopez Hernandez, in reference to getting her to sign these false hopes of these false guarantees that he made, even through his own line of questioning that he admitted to on the line of questioning, where he said that he was going to move heaven and earth to get her residency, to keep her residency. That sounds pretty much like a guarantee to anybody if you're telling them that they're going to move heaven and earth for her to keep her residency. So all these questions are going to go into his solicitation. his coercion, which could fall under the legal ramifications of barratry, Judge. And so he could always take the Fifth Amendment.
So I'm
as
going to
well.
sustain Mr. Castillo's objection. I think it's beyond the scope of your motion for temporary restraining order. So I'm going to sustain that objection. What else do you have?
Nothing further, Judge.
Okay, I'll entertain, if you don't have any other witnesses, do you, Mr. Hernandez?
I do not, Your Honor.
Mr. Castillo, do you have any witnesses for this hearing?
I do not, Judge. Thank you so much.
I'll entertain any argument if you have for the court.
Judge,
I have
Let me start with Mr. Hernandez.
may I please the court, Your Honor?
Yes, sir.
Judge, as you heard, the testimony is very clear. Ms. Lopez Hernandez went in without knowing what she was gonna. She went in for the immigration case. Mr. Castillo coerced her into signing this contract. He's filed a lawsuit on her behalf that she did not consent to. He had contacted her even after the cease and desist letter that we gave her. There is irreparable harm that we could suffer that could not be fixed any other way unless
tell me, please.
We need the temporary restraining order in effect so that Mr. Castillo doesn't mess up the wrongful death claim that we have pending and does not contact Ms. Lopez anymore and cause her to have this anxiety, and his office contact her, trying to convince her otherwise to stay with his office, or to go back with his office. And so we need this temporary order in effect, Judge, so that we can proceed properly with Mrs. Lopez's case. And we're asking basically, Judge, that Mr. Castillo or his office, not directly or indirectly, contact Ms. Lopez in any way regarding the wrongful death claim, and that they cease to attempt or represent Ms. Lopez Hernandez in any wrongful death claim or any related legal matter, and that they do not interfere at any point with our contractual relationship with Ms. Lopez Hernandez. And those are the three things that we're asking for in our temporary order, Your Honor.
Mr. Castillo?
Judge, I'm not opposed to the TRO as it stands. I'm not going to. I'll stipulate to it. However, there are some pending legal matters. I'd like to discuss those other legal matters with Mr. Hernandez, and hopefully we can conclude this situation.
Based on that, I'm going to grant the request for temporary restraining order as petitioner has filed. I don't recall, Mr. Hernandez, if you have the proposed order already sent. I had printed out several different copies of some things, so I don't know if a proposed order is there, solely based on the fact that Mr. Castillo is not opposed. I'm going to set this for a status. Let me see. Myrna, do we have any settings already on this one? Or is she still there?
Yes, Judge.
We do not, Judge.
Okay, so we are on the 15th. No, I'm going to set this for a status in 2 weeks via Zoom.
Thank you, Your Honor. And Judge, I will get you the order today. And I don't know, Mr. Castillo, I'll send it to you first for your approval, and then we can send it to the court.
Thank you for your time. That's exactly right.
Thank you, Your Honor. And Mr. Castillo, I will contact as well, and maybe we can get this case resolved, hopefully.
Thank you. We'll talk soon.
Take care. Bye-bye.
Thank you,
Thank you, Judge.